Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to This Week in FCPA, Episode 89 for the week ending February 9, 2018, the Eagle Soar edition. In this episode, Jay Rosen and I take a look at some of the week's top compliance and ethics stories. We considered Steve Wynn's resignation and Wells Fargo's continuing problems and what they tell us about corporate governance. We review an article by Bill Coffin, which takes a shot at Fortune's World's Most Admired Companies list. We consider leniency deals now offered by Japan for companies who provide information on other violations, such as anti-corruption and anti-bribery. We consider banks behaving badly, both Rabobank and HSBC. We note the UK Serious Fraud Office has opened an additional investigation into GSK for its actions in China. We ask, why does the ABA oppose transparency and anti-money laundering law reform? We take out a shocking look at the Pentagon for waste, fraud, and abuse of over $800 million, as uncovered reported by Brian Bender in Political. We talk about my pre-sale of my upcoming book, The Complete Compliance Handbook, and note the Compliance Masterclass I'm putting on Monday and Tuesday at Markham LLP in Florida in conjunction with Jonathan Marks. And finally, we reflect on the Super Bowl win by the Eagles over the Patriots. What were our final thoughts? This is Tom Fox. This Week in FCPA is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, back again for another episode of This Week in FCPA with my good friend and colleague, Mr. Monitors, Jay Rosen. Jay, we are on episode 89 for the week ending February 9, 2018, the Eagle Soar edition. Welcome.
Fly, Eagles, fly.
Fly, Eagles, fly. So, Jay, we had a very interesting week, I thought, in ethics and compliance. So some of our stories, I think, this week will really bleed into both. So why don't we just jump right into it? We had continued fallout from the Steve Wynn imbroglio. Steve Wynn, founder, CEO, and chairman of the board at Wynn Casinos, resigned his position from the corporate board for sexual harassment allegations. The reports were that I believe he paid $7.5 million to a woman he allegedly attacked, and there have been several other payments made, approved by the board of directors of Wynn Casinos. And Matt Kelly took a really interesting look at this from the corporate governance perspective, where he talked about what do you do when you have not the situation where the founder is a corporation and the corporation is the founder, but really when you've moved past that, you have a U.S. public corporation, yet you have a charismatic leader who happened to be the founder and still is very active in the success of the casino. So active, in fact, that in the latest couple of 10-Ks that when casinos issued, they noted that it would materially impact the corporation negatively if Mr. Wynn were to be gone. Whether I don't think they anticipated this type of be gone, but Matt really had a interesting way, or certainly starting with some corporate governance, good corporate governance strategies. One was to split the role of the CEO and the chairman of the board, but at the end of the day, he came down with a couple of different ways to look at it. One is more tactical, structural, where you have a robust compliance program that is merited, autonomous, and has authority within the corporation. So if any allegations arise, they can be dealt with. But also, and what I want to tie into with the Wells Fargo penalty, Jay, is the board of directors itself. And what's the responsibility of the board? Obviously, the board knew about this because they were approving payments. The payments to settle the sexual harassment claims did not come from Wynn personally, but from corporate money. So the board's aware of this, or does this make them complicit in this? And then even as today it was reported that the firm that had been hired to do the independent investigation of the allegations has now been terminated. So the board is the board hushing it up? The law firm had set up a reporting line for information and allegations and facts to be reported. That's been shut down. So what's the role of the board going forward? If you overlay all of that in a even more regulated environment, Jay, which the gaming business is, it's regulated in every state. The Wynn Casinos is attempting to open the largest casino in the East Coast, I believe, in Boston. So, and the Massachusetts Gaming Authority has indicated that even with the resignation of Steve Wynn, the inquiry into the company's fitness to operate or receive a license, or continue to hold a license, I should say, is in question. Whether that would move to Las Vegas or Macau, which is actually the biggest cash cow for the Wynn Casinos Corporation, it's still an open question. But what's the role of the board of directors in ethics and compliance? And is this something that regulators are going to start looking at more closely? I drew the parallel to the Federal Reserve sanction against Wells Fargo, where they restricted the company's overall financial growth and required new blood on the board of directors, specifically because of the lack of the board's response, both during the fraudulent account scandal and going forward. So I really thought there was a lot to unpack there. But interestingly, Jay, it's at the top of the organization. And it's things like tone at the top, conduct at the top, the role of the board. Should the board have compliance expertise on it? What should be the role of the board when a charismatic founder/leader engages in conduct that is, if not antithetical to good governance, certainly violates the norms of business practices and conduct? So lots for me to really think about and talk about. And what about from your perspective?
Yeah, I think you hit on a couple key points, Tom. One is that ubiquitous tone at the top that we're always talking about. And I think this is really migrating above the top, and it's really tone at the board. And there's going to be some other articles we'll take a look at this morning where people are advocating that the board can't just be there to be a rubber stamp mechanism, that there need to be folks on the board who have financial experience, who have audit experience, and these things cannot just be swept under the rug and hushed up. So, it's interesting how you draw that through line from, what was happening at Wynn Corporation all the way to Wells Fargo, that these are still folks who are operating with the old ostrich approach, putting their head, deep down into the sand. So I was just marveling to myself that everything we're going to go over in a half hour or less is some our articles and our stories that broke this week. So it's just amazing that how ethics and compliance is just really taking over corporate governance, and no longer are these things going to be something that can just be swept to the side.
Jay, next we had an article by my colleague, Bill Coffin, the editor at Compliance Week, that really resonated with me, and I think did so with you. It's entitled Keeping Bad Company, but what were your thoughts?
Well, throughout the year, we have all these lists of the world's best company and the world's most ethical. And, sometimes companies are voted on. Sometimes they apply and put themselves up. And, the list tends not to change much from year to year. And some of the folks that made the list for 2018 were Amazon, Google, Warren Buffett's Berkshire Hathaway, Starbucks, the Walt Disney Company, Microsoft, Southwest Airlines, FedEx, and JP Morgan Chase. And they're all very strong companies with proven histories of market dominance, innovation, and strong management. But then when you start to really dig down into this, Bill Coffin from Compliance Week has really pointed out that maybe some of these companies aren't as pristine as we think they were. And specifically with Apple, he cited that Apple is currently locked into major tax disputes with Europe because of the manner in which it's creatively exploited European tax law to essentially do business in the EU without paying taxes. And, although you want to minimize your tax exposure, that just doesn't seem something that a squeaky clean company would do. He also addressed Volkswagen and the fact that, even though it's maybe one of the world's largest car makers in terms of sales, that it's still the Dieselgate scandal is very close in its rearview mirror. And finally, he also talked about Johnson & Johnson and its campaign to discredit generic market for a painkiller that it had invented. So when drugs hit the generic phase, that's it, and you have to live with it. And J&J conducted a campaign to sabotage the generic market in favor of itself. Two more examples of the company that you keep is Samsung with their chief executive going to jail and actually getting out early for bribery. And the worst by far, which we just mentioned, was Wells Fargo. And there is such a toxic environment there that basically they've been prohibited to grow the bank, as you mentioned, because there's a cultural problem that cannot be fixed overnight. And unfortunately, they lack reliable indicators that the problem has been addressed much at all. So when you throw around some of the biggest names of the companies who are doing business globally, and they all seem to have this very weak Achilles heel of ethics and compliance, it shows that there's just so much work ahead. What were your thoughts on Bill's article?
So it really hit the highlights, Jay, and I have to agree with everything that you said. And he ends by talking about Wells Fargo, which is clearly the most egregious one to put on here. To claim that they are admired, I think belies not only every anecdotal story, but indeed every metric we've seen. And this is in the face of literally 10 days ago, the Federal Reserve Bank saying that not only has the company not fully remediated, the board of directors has not engaged in their obligations. And before you can actually grow your business, and think about that for a minute, this is not a fine or penalty. This is, you cannot grow your business until you get your house in order. And the estimated non-growth cost is going to be between $300 to $400 million, which more than doubles the fine and penalties Wells Fargo has already paid. Really belies Wells getting on this list. The same with Samsung. I'm a little bit less concerned with Johnson & Johnson, but even Volkswagen, you would think a German company would be more sensitive than any other companies on earth to gas testing, even if it's primates and even if it's volunteer humans. And that probably offends me as much as anything Volkswagen has done when that testing came out, emissions testing. So Volkswagen's got a pretty big open hole in their culture as well, and I certainly don't admire them.
All right. Well, next up, we have a story that's about Japan is offering leniency deals for companies which provide information and other violations. And this is from Michael Griffiths at the Global Investigations Review. We'll link to it, but a subscription is required. And I would say that 2018 is quickly shaping up to be the year of leniency deals in exchange for self-reporting. And we've seen this idea start to sweep across the globe, just as the U.S. has kind of taken the lead and, linked up with global enforcers. We've seen this idea now spring up in Singapore, spring up in Brazil, and spring up in China, and now with Japan saying as well, they're set to introduce leniency deals for bribery and fraud that will reward individuals and companies for cooperation, but only if they hand over the evidence that implicates others. This amendment to Japan's Code of Criminal Procedure, made in 2016, will actually come into effect later on in June 2018, establishing a mechanism for companies and individuals to negotiate reduced penalties for bribery, embezzlement, and fraud. And the regime, called the new system, allows prosecutors to dismiss or downgrade charges or recommend that a court impose a lighter penalty than it may have done otherwise. Lawyers in Japan, speaking on background, said that the system could be a way to offer cooperation credit to parties in a country that doesn't recognize legal privilege. Unlike jurisdictions such as in the U.S. and the UK, suspects aren't able to appear cooperative by waiving privilege over communications, because prosecutors are able to obtain the documents they would require with court-approved search warrants. So it sounds like, the ideas that were put first in the corporate enforcement policy seem to be gaining traction across the world. Your thoughts on this, Tom?
Yeah, and it's exactly your final point, Jay, which is that it's not leniency for leniency's sake. It's leniency for information, and it's leniency for agreeing to certain remediation going forward. So I think a welcome step, whether it's called a leniency agreement, as in the Brazil under the Clean Companies Act, whether it's called a deferred prosecution agreement in the United States or the United Kingdom or something else. Certainly a welcome addition, certainly a way for investigators, prosecutors, and enforcers to garner more information and, frankly, make compliance more ubiquitous by companies agreeing to remediate fully. So I thought it was a positive step. Certainly having Japan step up and recognize its obligations under the OECD to move forward with a greater focus on anti-bribery, anti-corruption is a good thing. So now, Jay, we continue the saga, or the continuing story of banks behaving badly. You want to take us into this one?
Sure. So this one, this first story might augur for us actually to have a wall, but we need maybe a money laundering wall between Mexico and the U.S. And I guess, do you say Rabobank? Am I saying it correctly?
Rabobank.
Okay. This is the U.S. unit of a Netherlands-based Rabobank pleaded guilty Wednesday to felony conspiracy for concealing defects in its anti-money laundering program and obstructing a federal investigation. Rabobank National Association, based in Roseville, California, will forfeit $368.7 million for allowing Mexican drug money to be processed to the bank. 2 months ago, Rabobank's former anti-money laundering investigations manager, George Martin, pleaded guilty to aiding and abetting AML failures. He agreed to cooperate with federal investigators under a 2-year deferred prosecution agreement. And some kind of shocking statistics that the article mentions. This is Dick Casson writing in his FCPA blog, and it says, basically, Rabobank's AML system alerted staff to suspicious accounts, but managers told the staff to ignore the alerts if the customers appeared on a, quote, verified list, unquote. In 2009, there were less than 10 verified customers. By 2012, there were more than 1,000 verified customers, the DOJ said. So that, again, if you're looking at the greed and the avarice there, they have banks set up right on the Mexican border. They are dealing with high-risk individuals. They are shirking their AML responsibility, and then they're not throwing drug money into teddy bears, but they're actually just cleaning the cash right there and using it at the border. So Sam Rubenfeld also took a look at that in the Wall Street Journal, which we'll link to our show notes. And basically he said that this is signaling a shift because we're seeing banks being prosecuted for covering up the violations as opposed to the violations themselves. So that's the good word on Rabobank. And then we also have HSBC, who has been in a similar predicament, and they're being taken to tax again for its chronic recidivism and how they deal with AML laws. So your thoughts on this, Tom?
I really like the way the bank put this business unit close to the border, and then claim, oh, we don't know anything. It seems like the entire business plan was to get Mexican money to launder it through, and I hope that wasn't it. But nevertheless, it demonstrates why your geographic location can change your risk profile. So any bank that is on the Texas-Mexico border has a Latin American focus, as many banks do in Miami, need to have robust money laundering anti-money laundering departments, and understand that the government and regulators and under banks, that would be the Federal Reserve, they're going to be looking closely at you because you are in high-risk areas. And in a corruption world, that translates to, if you're doing business in a location that is prone or perceived to be of high corruption, you need to have a more robust program in place, because the regulators certainly will come.
All right. Well, next up, we're going to go across the pond, and the SFO is reopening investigations into allegations of GlaxoSmithKline's corruption in China. Why don't you tell us about that one, Tom?
So this one is both surprising and unsurprising, Jay. For anyone who followed the sad saga of GSK in China, they'll recall that in the summer of 2013, approximately 50 GSK China business unit employees were arrested, detained, or interviewed by Chinese authorities. 1 year later, GSK was convicted of paying bribes in China, assessed approximately about $497 million fine. 4 corporate executives were personally convicted. One UK citizen, the country manager, he was deported. 3 other Chinese nationals served some period of jail time. The Serious Fraud Office has never sanctioned GSK for its actions in China. There's never been any report of how far up the chain this went. It went at least to the head of the business unit in China, but we don't know what happened in the corporate headquarters in the United Kingdom. The Securities and Exchange Commission assessed a $20 million fine to settle civil charges that Glaxo had violated the Foreign Corrupt Practices Act. There was no corresponding DOJ fine. Certainly, you have to understand that this information has been communicated to both the SEC and Department of Justice about the SFO inquiry. So it's possible that either the SEC could reopen their case, or the Justice Department could reopen theirs if it was ever closed. So these allegations, though, are against GSK's use of third parties in the bribery probes. And this was a little bit surprising. The surprising part is because this was a prominent feature of the original underlying case. GSK paid a little over $500 million out basically through third parties to pay bribes to sell drugs in China. They paid bribes to doctors. They paid bribes to hospital administrators. They paid bribes to government officials in health ministries. There was an entire bribery program and scheme set up. The bribes were paid through the anomaly of what the Chinese call travel agencies. Now, that's not the typical U.S. or Western travel agency that you and I might think of, Jay, but these were groups that set up conferences and did large speaking engagements. And the competition for these positions or contracts with GSK in China was so great that these travel agencies actually bribed GSK in China business unit employees. So this information has been around quite some time. So the surprising thing is that there's just this announcement now. On the other hand, it's completely unsurprising to me that it's being investigated. Although, once again, I would ask why almost 5 years after the original story was reported in the press, this is now subject of a SFO inquiry. But very interesting case, had a lot of sexy things. There was even a sex tape scandal. So we'll just have to see where this one takes us, Jay.
Yeah. So now it's a very interesting article that you uncovered from the Global Anti-Corruption blog written by our friend Matthew Stevenson. And he asked the question, which you will attempt to answer: why does the American Bar Association oppose transparency and AML law reform? What are your thoughts on that?
So this was actually, I found it to be quite disturbing, largely because the American Bar Association has taken a formal position against transparency for the beneficial ownership question of corporations. As you know, Jay, we were named number 2 in the world for opaqueness and lack of transparency in beneficial ownerships of corporations a couple of weeks ago, the We're Number 2 episode that we went over. And this is a gaping hole in the American legal system around money laundering and anti-money laundering. And so there have been various legislative attempts to require the naming of the owners of corporations. And that's all we're asking here for, or asking Congress is. And here, the American Bar Association actually has sent a letter opposing it. Now, there are 3 bases for this that Professor Stevenson opines on. One is the cost of compliance. And you have to say that's laughable on its face, because every bank has robust systems around know your customer. The second is that, and this gets into obviously legal eccentricity, but it's equally inane. The ABA's other major objection is that the bill could, not does, but could impinge on lawyer-client confidentiality. And even Professor Stevenson writes, this objection carries essentially zero weight with respect to the part of the bill that requires applicants or their agents to provide beneficial ownership to the government. So to say that by requiring a company to name who its owners are impinges on the attorney-client relationship only holds water if you're trying to evade the law. So it's really worse than zero. And then there is one other point that he raises, that lawyers who in the bill would be called formation agents, it's i.e. lawyers who help form corporations, that subjecting lawyers to the requirements of AML law would be an infringement of traditional attorney-client confidentiality. And I find that equally specious because banks have to do this. It's not revealing a client confidentiality to name a client in a public setting. It's certainly one thing if a client comes to me and says, look, I've broken the law, I was drunk and killed someone, but I do not allow you to disclose my name to authorities. That's attorney-client privilege. That's confidential information to a client. And there's actually cases that say attorney cannot be required to release that information on the name of the client if they've committed a crime. But this is simply, getting a corporation set up. So it's really, I think, a very, very bad position taken by the ABA. Professor Stevenson further opines that there's appear to be 2 groups of lawyers who are pushing this. One is small firms or solo firms who provide corporate registration services and who would indeed find it more difficult to operate if they had actual scrutiny on them. And then the flip side, of course, is large firms who represent very wealthy, shady characters who help these clients set up complex financial and legal structures to shield their assets. And here you only need to think of the Panama Papers firms involved in that. So he has tried to find out who at the ABA authorized this. Typically, you would only have an important decision on taking a formal position on legislation approved by the House of Delegates, and there's no House of Delegates vote or resolutions on this. So this is going to be a continuing story, but it really brings up, Jay, the larger issue of the difficulty in AML reform and reform of beneficial ownership. Once again, this is simply requiring people who form corporations to list their true owners. And if we can't get this passed in the United States, we've really got no hope of having substantive AML litigation or legislation put in place.
Well, very, very interesting article. And the thing that I kind of focused in on when Professor Stevenson talks about some of the opposition that remains, it's the usual players. And he opines that the sources of opposition are, in some cases, predictable, such as the Chamber of Commerce, for example, that opposes these reforms, as does FreedomWorks, the lobbying group sponsored by the libertarian billionaire Koch brothers. One of the major opponents of the legislation, though, was more surprising, at least to the professor, was that the ABA, which represents the legal profession, the ABA has come strongly against this legislation, sending letters to responsible committees in both the House and the Senate, expressing strong opposition to even relatively mild reforms. So, you've got these regulatory forces that are out there, but this isn't even, as you said, Tom, it's not even regulatory. This is just common business practices. And if we can't be transparent on who we are and how we're doing business, it truly puts us in a bad place. To lead the discussion about ethics and compliance and corruption to a place where we would never think it exists, the Pentagon, according to EY, has lost some money, maybe even millions of money and millions of dollars worth of taxpayers' money, or billions or trillions. And this story comes to us from Brian Bender in Politico. And what did E&Y have to say about the DLA, Tom?
So I know, just as I can tell the absolute shock and surprise in your voice that lawyers would ever do anything that would try to benefit lawyers or even their clients, you're shocked to hear that there's waste, fraud, and abuse going on at the Pentagon and the Department of Defense. And what E&Y found was that the Defense Logistics Agency had failed to properly document more than $800 million in construction projects where there was no auditable paper trail. And as Senator Chuck Grassley said, if you can't follow the money, you're not going to be able to do an audit. If you can't do an audit, you can't see where the money's been spent. So this is, I would say, incredibly damning. I would also say, I'm not really surprised. Waste, fraud, and abuse at the Pentagon. But it really points up to the need for robust inspections, robust inspector generals, and robust oversight. And I know, Jay, that I believe your colleague Eric Feldman came out of the IG's office, and that the inspection of contracts and the inspection of a series of contracts is an important part of every government agency's remit. And that theory or that philosophy also goes across to the private sector, i.e. the world that you and I work in, so that an ongoing monitoring at an outside audit and having a true expert come in and look at something can help companies run more efficiently by keeping waste, fraud, and abuse out of the system. So I'd like to tell you I'm surprised, but the reality is I'm not.
There is some spokesman at the DLA that was able to put a positive spin on this, and this will be the last thing I'll share in it. Quote, each audit report will help the DLA build better financial reporting foundation and provide a stepping stone towards a clean audit of our financial statements. The findings also improve our internal controls, which help to improve the quality of costs and logistics data used for decision making. So, it appears there is some positive coming out of it. It's just unfortunate that it would take almost $1 billion audit from from EY to find this out. So, Tom, spinning now to some of some good stuff that you've got going. Why don't you tell us about how pre-sales are going on the new book?
So pre-sales are going briskly. The Complete Compliance Handbook is still scheduled for a mid-April publication. It's available. Information's available on my website. If you'd like more information, you can certainly email me. I've got a flyer I can send you on it. Getting ready to do several more promotional efforts on various different platforms. So a lot of information is going to come out about it, and I hope you'll take a look at it. I'm still very excited that it's being published, and very excited to have completed it, but even more excited to have it published. And when I can get a copy in my hands, I'm sure I'll be very excited then as well. It's not too late if you're interested in attending the Doing Compliance Masterclass. I think we have one slot left, Monday and Tuesday in Miami. Jonathan, our good friend Jonathan Marks at Markham LLP is hosting the event, so I'll be doing it with Jonathan. He's one of the top forensic auditors and internal auditors around, certainly in fraud, waste and abuse, and FCPA anti-corruption. So I'm looking forward to that. But Jay, here's the part I've been really wanting to ask you. Because I think you're aware the Patriots lost the Super Bowl last week, or actually I should say the Eagles won it. The Patriots didn't lose it. But what were your thoughts on the game?
As most of the Tom Brady, Bill Belichick Super Bowls, it was truly exciting. It went down to the end, and it looked like Tom Terrific almost was going to pull another rabbit out of his hat, and I don't really have any issues with the way it went down. Tom is 40 years old. He threw for over 500 yards of offense. When you score 33 points in the NFL, if you have a mediocre defense, when you score 33 points in the NFL and you have a mediocre defense, you should usually be able to win those games 90% of the time. And with the exception of a strip sack, a poorly executed reverse on a kickoff, and with the clock running out, the Patriots missed their last gasp. But I just tried to be upset and sad about it this week, and I couldn't be because I think it really came down to the Patriots defense not stepping up. What do you think about your perspective from the Eagles side?
So I think it's unfair to ask for my perspective from the Eagles side, since I wasn't pulling for the Eagles. A couple of things, observations, Jay. The Malcolm Butler benching. We have not heard a official reason why he was benched, and frankly, I think that cost the Patriots a Super Bowl. You took out your best cornerback, and they feasted on his replacement the entire game. So I'm sure Belichick had his reasons. I know he did. What they are, I don't know if we'll ever find out. But that one was really inexplicable. I don't know how many more times we're going to be able to see the Patriots in the Super Bowl. We've got, as you said, a 40-year-old quarterback. I was watching Rob Gronkowski obviously throughout the whole game. He had a terrible first half. He was almost the old Gronk in the third and fourth quarters. There was one 75-yard drive, I think, to start the third quarter, of which 70 yards he accounted for. But I was watching him run, and he is just clearly, he's not a shell of himself, but he's certainly not what he was. And so I wonder how many more years, if any, we'll have Gronk on the Patriots. Your point about the defense, they just didn't have the speed to keep up with the Eagles. But now let me flip over to the Eagles because, as I said, the Eagles won this game, in my opinion. and they won it because of the coach. And the coach understood he could not be predictable. He could not do things that he had done throughout the season. And most importantly, he couldn't do what Atlanta did, which was completely change their game and be gassed in the fourth quarter. He rested his troops. Part of that was the middle of the fourth quarter with 9 minutes left. The Eagles got the ball and had a 7-minute drive. So their defense had a 7-minute rest. And as you pointed out, the strip sack happened in the first series after that touchdown by New England. So a great game, greatest amount of offense of any game ever, not just in the Super Bowl. Sorry to see Tom Terrific not win it, but certainly I thought the Eagles were the better team last Sunday.
And another point that people made is really a battle of the backups versus Belichick and his brain trust, because you had the coach of the Eagles who formerly backed up Brent Favre in Green Bay. You had Frank Reich, who formerly backed up Jim Kelly in Buffalo. And then you had the Philadelphia quarterback, who not only was the quarterback in Philadelphia under the Chip Kelly regime, but he was basically, for all intents and purposes, on the scrap heap. So I think all these three backups came together, and like you said, Tom, they really put the foot to the gas when they had to, and it's almost a tale of both teams decided to run trick plays with quarterbacks as receivers, and Foles caught his, and Brady's just glanced off his hands. And in social media, who is the amazing wideout for Pittsburgh, who is just gangbusters?
Yeah, I can't remember. I know who you're talking about.
So anyhow, he tweeted Antonio Brown tweeted to Brady that he might be able to help him out with some of his pass catching issues.
Well, on that note, Jay, you want to take us home?
Sure. So on behalf of Tom Fox, the compliance evangelist, and myself, Jay Rosen, Mr. Monitors, we'd like to thank you for joining us for this week in FCPA episode 89 for the week ending February 9th, 2018, the Eagles Soar edition. So we hope that Jonathan Marks and all those people in Philadelphia are really taking the opportunity to celebrate their Super Bowl victory. Thanks so much for listening, and have a great week.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of This Week in FCPA. I hope you'll join us again next week, where we will review the week's top compliance and ethics stories. If you have listened to this podcast on iTunes, I would appreciate it if you would rate our podcast. It would help in getting out information on the only weekly FCPA compliance and ethics review. Also, if you have any questions, you can email me at tfox@tfoxlaw.com. You can email Jay at jrosen@affiliatedmonitors.com. Thanks again for listening. I hope you'll join us again next week. This Week in FCPA is a part of the Compliance Podcast Network.